Plain Township Zoning Commission's duties include the following: to make recommendations to the Board of Trustees with regard to amendments to the zoning text and map. The Zoning Commission does not have to prove to any applicant why his or her land should not be rezoned, but rather the applicant must prove his or her case for the proposed change. Any amendment adopted by the trustees becomes effective 30 days from the date of such adoption unless a petition for referendum is filed within that 30-day period. Specific requirements for a petition of referendum are set forth in Chapter 519 of the Ohio Revised Code and Chapter 3501.38 of the Ohio Revised Code. The hearings of this body are recorded to maintain a permanent record. All testimony is given under oath. All speakers must sign in and identify themselves by giving their names and addresses before speaking each time. Speakers are to only address the board and must provide factual evidence. Conversation between the speaker and the audience will not be tolerated. The applicant speaks first and presents his or her request. Next, anyone in favor of the application may speak. Then anyone in opposition may speak. We'll call on you at the appropriate time. Please appoint a spokesperson to express a group's viewpoint if you're here with a large group or number of persons who wish to express the same viewpoints. The board members will vote and reach a verdict on their decision, which will be announced. Should any additional hearing be necessary due to a continuance or postponement, the amendment will be rescheduled for the next available meeting date and no additional notices will be provided. Anyone wishing to testify tonight, I'd ask you to stand and raise your right hand so we can administer the oath.
Testify if you need to speak.
Yes. Anybody who wants to speak to us on favor of or against what's going on tonight, just raise your right hand. We're not going to have your testimony at this time. We're just going to swear everybody in that's going to. Do you swear or affirm that the information you are about to present or will present later is true and accurate to the best of your knowledge and belief?
I do.
Okay. Have a seat. Okay. So let's look at the agenda for tonight's meeting. Will you, Tom, will you call the roll for the membership?
Ms. Holder.
Here.
Mr. Craig.
Here.
Mr. Seeberger.
Right here.
Mr. Rambacker.
Here.
Mr. Crawford.
Here.
And Mr. Harris.
Here. Do we have any proposed changes to the agenda?
No.
I'm told that the minutes from the last meeting of September 3rd are not available for review and approval, so we'll move past that item on the agenda. Is that accurate?
Yes.
Okay. All right. Do we have any unfinished business that anyone wants to bring up? Okay. So we'll go to new business, being amendment number 574-19 and 575-19, dealing with generally skilled gaming. The applicant is the Plain Township Trustees, seeking a text amendment or multiple text amendments related to those subjects. Is the applicant ready to proceed?
Yes, sir.
Okay. And Tom, you'll be presenting on behalf of the Township Trustees tonight?
Yes, sir.
Okay. Go ahead and, if you would, tell us about the application.
The original definition for skill games in our current resolution is very old. The Ohio Revised Code was changed. Actually, the administrative code, 3772-50 of the administrative code, was changed and defined skill gaming. The board felt that with a new definition for skill gaming, or I shouldn't say new, revised, that we should update our definition as well to match Ohio Revised Code. So what you've got before you is basically the text out of the Administrative Code, Chapter 3772-50.
Tom, that would be from the definition section,
Yes, definition.
so that would be 3772-50-01.
No, that is from the Ohio Administrative Code.
I'm reading a copy of the Ohio Administrative Code
Okay.
section. I'm just trying to be more, want to make sure we're on the same page.
It's O1V through
It's
O1.
O1V, W, and Y, I believe.
V as in victory,
V as in victory, W as
W,
in
yeah.
winner, and Y as in
And why?
YMCA.
You got that?
I believe those are the three definitions
Yes.
that we're talking about.
okay, so, Tom, what do you want us, what else do you want us to know about the application?
That's about it. What I put before you in your booklet is the new proposed definition, the old definition, and a numbered proposed definition, so you can make notes as you go along.
I also see there's an application to delete where where uses of these skilled gaming devices, which districts they may be used in.
Yes, sir.
Could you speak to that, please?
Yes, sir. The skill gaming has become a bit of a problem. I don't know why Plain Township has so many. At one point, we had 21 or 22. Other townships have, if they have a lot, they have a half a dozen. The ones we have seem to be grouping in areas. Whipple is a good example. We have 3200 Whipple with a gaming spot, 3202 Whipple with another gaming spot, 3206 Whipple with another, 3210 with again another. They seem to group together, and the fronts seem to bring down the shopping centers that they're in. Over the last year and a half, we've been having a lot of problems with them. The township itself hasn't had much, but law enforcement has. Approximately, in 2018, May or June, somewhere in that area, the FBI and IRS raided 4 or 5 of the gaming spots here in the township. They raided possibly half a dozen more spread out in other areas, other townships. The IRS and FBI again, in May of this year, raided 4 or 5 spots and closed them down. Again, the sheriff's department made 5 raids in September 19th and closed them down. So we're having a lot of apparently illegal activity where law enforcement is coming in and closing them down. The board is looking at putting the gaming in one spot where it can be better handled, I suppose. That they want to, since they're so much of a problem now, they prefer to put it in the industrial zone.
The I-2.
I do.
I do notice that the I-2 is also the area where adult entertainment activities are delegated. Is this the policy or the thinking that,
Yes.
that the less desirable activities are those activities that may be undesirable to have proximate to our other businesses?
Yes,
That
sir.
this would be the proper way to deal with it?
Correct.
Tom, is it my understanding, it was reported in the paper today that the existing locations will be grandfathered in. Is that accurate?
Yes.
Can I ask a question?
Not,
Yeah.
Oh, okay.
Go ahead. The I-2 regulations, for example, for some of the other undesirable activities like adult entertainment, require a spacing, that no two can be located within a certain distance of each other, is, I don't see in the proposed amendment that kind of spacing is being asked for at this time. Is that
No, it is
accurate?
not.
Has there been any consideration for that?
There wasn't, and that's probably largely my fault.
When
I
I
didn't
say
even
fault,
think about it.
yeah, I'm just wondering if the policy is partly motivated by the fact that there are large groupings of this kind of activity in one location, that might be something that should be
Something we need to
considered.
think about, yes.
Okay. Anything else you want to report on behalf of the applicant?
I think that's it. Unless you have, anybody has a question?
there's two proposed resolutions, correct? The one changes the definition
Yes, sir.
to compliance with Ohio law. The second one restricts the areas where new ones can be open to industrial I-2.
Correct.
Now, we've seen the regional planning recommendation for
Yes, sir.
this, and they did send up a redlined or annotated version of the text amendment back to us. Did you,
I made those corrections, yes, sir.
okay,
We're talking grammatical corrections.
Yes.
And the like.
Yes.
Also, one of the suggestions, I believe it was in the RPC recommendation, Regional Planning Commission recommendation, was that the definition of skilled gaming is actually referenced as a specific reference to the Ohio Revised Code. And they are differentiating that between the Ohio Administrative Code provisions that we're relying on. Do you see any inconsistency there that should be corrected before the trustees act on this?
The original text that we sent down early on did not contain the administrative code. It only contained the Ohio Revised Code, section 3772 and section 2915.01. Those two don't speak directly to skill gaming. They speak to gambling, to casino gambling in general. The 3772-50 from the administrative code speaks directly to the skill gaming.
As we discussed earlier,
Yes,
those three subsections
Yes.
of the definition section. Okay.
Okay, so then my question becomes, when we're changing the definition of skilled-based amusement machine, and it says, see Ohio Revised Code, section 3772 and 2915.01. There's no definitions there, is that right? We're specifically referencing the administrative code.
Yes, the reason that those were added was because, that it covered gaming, gambling and casino gaming. And I thought that, it would tie in.
And clearly, administrative code provisions are developed pursuant to a statutory authority.
Right.
And so it would be appropriate to address or indicate the revised code section that's applied. But if we use the word "and," I'm wondering if we're not limiting it and that it shouldn't be "or." Might be a nuance or a fine point, but if we're referencing a definition that appears only in the one place, but you're saying see 3 different places and.
Well, I don't, because they've actually changed the definitions, and as long as they line up with what's in the administrative code that's being specifically referenced, I don't know that there's a problem with that.
Really just strike through that whole thing that says skill-based amusement machine, see the Ohio revised code, et cetera, et cetera, et cetera. We don't need that.
Or we say as defined in, rather than see.
Yeah, but we're defining it,
Yeah.
we go on and define it.
We find it exactly the same,
Well,
because 291501 of the revised code does define skilled amusement games, but I don't see the A, B, and C there.
That's in the administrative.
That's the
code.
administrative code.
Right.
Then, I guess the question is, can we lift the language word for word without making mention of where we got it?
Sure.
If that's what's required,
Done all the time.
then I agree, just delete the whole first line.
So that would be line number 3 and line number 4?
Yes. I mean, you can leave it in there if you want, it just needs to be revised if you leave it in there. Because it's actually Ohio Administrative Code based on Ohio Revised Code 3772, right? It's the enabling legislation.
It would be up to the board whether it stays or not.
Well, I mean, that's,
Or it gets revised.
Okay, so we really have a separate definition of a skill-based machine, and we've really not said that a skill-based machine has, or have we said, that there are 3 types of
Yes.
skill-based machines, and that they are, I mean, that might be the obvious. And we've,
type A, skill-based amusement machine that does not enable or entitle a player, entitle a player to receive tickets, tokens, vouchers, coupons, merchandise, or any other thing of value. However, delivered, and that, there's a semicolon there, it should be a comma between value and however. Points or any other score keeping, should be a hyphen between score and keeping mechanism, cannot be exchanged for anything of value at any time, including a merchandise prize or redeemable voucher. And then there's an example that's not part of the Ohio Administrative Code definition, but otherwise it seems to track that. It seems to be that's what they did do. I've only read the one. I'm assuming the other 2 follow the same. We could take them out and just refer to the specific code sections. That way, in the code sections change in the future,
we don't have to
you
redo
don't
it
have to
every time.
necessarily redo it every time they change the code section.
Is that the intention, to follow the state law, to make the state law our definition?
Yes.
Well, that makes sense. And then what,
That does make sense.
Well, I mean, they could change the code section, and when they change it, they add stuff so that the numbers and letters don't line up, but then often they don't, often they just change the language in the code section and stay the same, so we might be able to avoid a future change or revision in the Ohio Administrative Code by just simply referring to it. Or we could say by definitions of, quote, type A skill-based amusement machines, which are,
As defined
As
in
defined in-
377250001.
yeah, type A, type B, and type C.
And then if they change it, ours automatically change with it.
What do you think?
Can you do it?
Sure, we can recommend it.
Right.
okay, enough on that one then. I guess we can get back to that. The amendment would separate, according to the staff of the Regional Planning Commission, the amendment would separate the skill-based amusement machines into three categories or types, depending on their award system. And it appears that the wording for these types of machines was derived from the Ohio Casino Control Commission, which may conflict with the ORC.
Well, I think that they're saying that because that code section doesn't actually address, the Casino Commission doesn't actually address these games.
Okay. The proposed amendment defines skill-based amusement machines as types A, B, and C. However, these are not proposed for inclusion as allowable uses in any district. Instead, internet cafe or skill games are listed. Do you want to address that at all, Tom? I mean, it seems like they're making a valid point, but I don't think it's contrary to what we're trying to do. They're saying that we should be listing the machine types as the uses rather than just generally skill-based amusements
The,
or skilled games.
the type A and type B are arcade type games. Kids will go in and play the games, they'll get tickets and they'll bring the tickets up to the cashier and trade them for a prize up on the wall. I didn't have time to change anything once we got that, but it might not be a bad idea if we looked at.
Are those kinds of activities, the arcade machine, are those the offensive types that are wanting to be put only in industrial areas, or are those the kind that are okay, like in a convenience store or whatever, that we're okay with?
These are not, the type C games are the games we're speaking to.
Okay.
That the trustees are speaking to. The type A, if you look at line 14, it says classic arcade style games. Those would be more for children, the way I take the wording.
Yeah, A and B are Chuck E. Cheese, right?
Yeah.
So do we want the Chuck E. Cheese's to be only in I-2?
No.
But I'm not sure that that's not what your amendment is saying.
And I think the RPC is correct in that.
So the only definition we really need is subsection Y, type C skill-based amusement machine.
I think essentially you're correct. If
You
we're
guys-
not going to include, but does it hurt the definition? We're not talking about where these games go right here. This is strictly a definition of skill gaming, and I don't think it hurts here.
Well, except when you go to the use, or to the district's designations of what's going to be allowed where, you're calling them skill-based amusements
or internet cafes.
And so if you don't say that only the type C is the skill-based, that you're trying to limit to I2, then you basically prohibited A and B in any other district but I2, which I'm hearing you now say that that might not be exactly what we're trying to accomplish.
I believe you're right.
Do you sense a degree of urgency by the applicant that maybe there was a rush to get this through and maybe it could use a little more polish? Maybe I'm putting you on the spot. I'm not gonna,
Well,
you can answer it if you want.
RPC's response came a bit late for me to be able to make the changes. The way this is worded now was recommended by the legal department. And so we took this recommendation and ran with it.
Did the topic we're now bringing up, this variation between machines A, B, and C, come up in the discussion of the?
No, not until
okay.
RPC brought it
And do you think that's a significant consideration?
up. I believe it is.
Just so I understand, okay, of the three types, the A, B, and C, C is the one that is believed to be objectionable other than in limited locations.
Yes.
There's no real concern about type A and type B.
No.
So it was pointed out to my right-hand side, I mean, perhaps the definition of a skilled-based machine could literally just pick up the Ohio Administrative Code definition of the type C machine. That could become the new definition for skill-based amusement machine for the purposes of Plain Township, and then you could delete the items from industrial 1 and business 2 with respect to skilled games, because there is no definition of skilled games.
Or internet cafe.
Or internet cafe in our book, and then modify the permitted use in B2 from skilled games to skill-based amusement games, so that you have a consistency between the definition section and the use regulations. Just my thoughts. I'm very happy to see all of this, because I may take this to a couple of communities I represent and get their books up to date too.
So, just to clarify, so it's I2 that is going to allow these?
Yes.
Okay. So, should there be a proposal, what's it say in I2 right now? Because I don't see that. I saw deleting it.
Oh, they're allowed in I2.
Right, but
Under
what's the
old
wording?
definition.
What's under the old definition?
Let's look, but I think it's skilled-based, I think it's internet cafes and
So that's the language that used in all three.
skilled games,
Yeah, that's,
rather than the word skill-based amusement machine.
right.
And we better be specific if there's that fine a line between what's gonna be permitted, maybe in the old B2s, but not,
Yeah, I didn't understand that you were trying to just limit C, and that you were, so, okay, all right, I gotta rethink this.
I think by limiting the others, then you take the opportunity for a business like the pizza, and you're limiting them.
Yeah, I mean, let me try and summarize. What the trustees wanted to propose was to limit the type C machines as defined under the new Ohio Administrative Code section, or revised code section, and limit those type C machines to just I2, industrial 2 zones.
Yes.
And that's all they're trying to do, but they have to make a few changes to the existing regulations to make that work.
Yes.
Okay, they did it a rather torturous way.
They did.
Tortuous or torturous?
Both.
I think you need all three definitions, A, B, and C. In items 12 and 16, you don't delete internet cafe or skilled games, you change it to A and B. And then in L, or I2, you change that to C.
That
See,
makes more
or-
sense.
Yeah,
C only, it can, C
C
is a permitted use only in I2.
in I2,
Whereas
but
A
we
and
don't,
B are still permitted uses in,
item 12 and
B2
item
and
16, which are B2 and I1, yes?
If that is in fact what the applicant is wanting,
yeah,
and it sounds like there really hasn't been enough time for the applicant, being the trustees, to react or fully to the recommendations of the RPC with respect to those definitions. And I was reading the RPC recommendation, and the next one, number 4, was the amendment would remove skilled games from allowable uses in B3, which I think they meant B2, and I1 districts, only allowing them in an
So they
I2
said it right
district. The
there.
township may want to consider allowing type A and B machines in the additional districts.
Right.
And that's what motivated my questioning earlier. Okay. Then it goes on to say there are a number of grammatic changes, and we understand grammatic changes. And it also goes on to recommend that legal counsel, that the staff encourage the township to ensure that their legal counsel has reviewed the amendment for sufficiency and compliance with applicable laws. I do see our township law director signed off as to form, but not as necessarily as to any other matter. This all seems like such a,
Tom, as a representative of the applicant, what are your thoughts given our recent discussion?
including consideration of agreeing to postpone the consideration of the amendment to the next meeting, or another one soon. I'm just asking you.
Are they
You
anxious?
don't have to do
I
that.
think that in order for me to get this done, we would, it'd be best if we table this meeting until November.
I do like the idea of saying skilled, whatever, amusement machines, skill-based amusement machines will be defined in Plain Township as defined in Ohio Administrative Code, da-da-da-da. And then if they change it, you guys don't have to go through the change again. Whatever the state says it is, that's what it is for Plain Township. And then, you don't have any more grammatical errors to worry about. Right? Because all it has to say is, as defined in Ohio Administrative Code 30, whatever it was.
3772-15-01-
That V or something.
VY.
Why?
Well, there are a few different ones, right? Are they all in that one?
Well, the one that they're trying to restrict, as I understand it, is Y.
Why?
But we want, if we want A, B, and C, we want to include those, whatever those are, M, you know, whatever the letters are.
I don't think we want them, we don't object to A and B.
Right, but if
Yeah,
we
but
just
it's
say
not-
Y, then we haven't enveloped that definition. We could just do
Yeah,
the whole
no,
thing.
we could just say Y, and the other two are okay. And they're not trying to restrict.
But we haven't defined it.
V and, well, but they,
Well, we don't,
but we're not restricting them.
we don't
are
want
we?
A and B in residential zones, that's for sure,
They'd be in business anyway.
yeah.
Except it's not cleanly presented that way in the application that's in front of us. That's my concern.
Yeah, I mean, it's, to me, it's such that I'm not sure from reading it, when first time I read it and the second time I read it, I wasn't sure what it is they really were trying to do. So that's,
As far as the
that could be a
definition-
failing on my part, but I mean, it was confusing to me as to what they were trying to do. And so it would be hard for me to sit here and say, here's what they were trying to do. That's why I keep asking you what they were trying to do.
So you're talking about the definition itself, or
how they did it, what their objective is, so we can see if they've actually, if what they're proposing is gonna accomplish that.
And would referring to the proper section in the Ohio Revised Code solely that reference to it without the language, is that sufficient?
I think
Ohio
it'd be
Administrative Code.
I think it'd be sufficient to say as generally defined by state law, and at this time, which is blah, blah, blah.
Yeah.
And if state law changes, whether it's a new administrative code section or a new revised code section, we still have built-in flexibility that basically the township is adopting the state standard.
If you just put,
Unless it changes.
Eric can help you with that. That's why they're talking about getting the law director on in reviewing the amendment for sufficiency and compliance with applicable laws. I don't think we have to rewrite that for you. I think that it's not rocket science. They'll come up with something correctly. Okay. Anything more you want to present on behalf of the applicant at this time?
No.
Because so many people have showed up and there've been at least one person indicating a willingness to talk,
More came in
a
later.
couple more. Has anyone else come in that wants to weigh in and speak tonight on the matter before us? We had one man stand up and gentleman stand up and was administered the oath. Do we have anybody else? Okay. So is there anyone else here to speak on behalf of the proposed amendment? Is there anyone here to speak in opposition to the proposed amendment?
I have a question.
Okay, come on up. You were the fellow that raised your hand and swore that you wanted to testify, okay? That's fine. Would you state your full name and address for the record, please?
My name is Sam Lopez, and 4805 16th Street Northwest.
Is that in Clay Township?
No.
In Canton?
Yeah.
Okay. All right, go ahead.
He had mentioned that in the past, Mr. Ferrer mentioned in the past, there was legal issues like the IRS, FBI, or whatnot. Does that have any bearing on the skill game businesses that are operating today? And I guess I should say, are the people that have been under scrutiny by those legal offices, do they own a skill game license today? Or are they going through legal processes that haven't been solved yet?
Okay, you've asked a question of the board. It's not appropriate for direct communication.
Oh, sorry.
However, I think I can maybe summarize your question by, is this intended to punish people that have been law-abiding operators, or is this specifically to address persons that are violators of state law? Is that a fair question?
Sure.
I would think that it is to, because we've had so many 15 to 18 establishments that have been raided, it's difficult to tell who's legal and who's not legal.
I see. So in other words, just a policy matter that trying to tighten it up, although we know that any existing establishments are going to be arguably grandfathered, so kind of the answer to your question is probably not going to affect them at their current locations. Just going forward, they're trying to tighten it up so that it's not negatively affecting the other business uses.
When you say grandfathered in, who is going to be grandfathered? Just the businesses that are currently open? Not the ones
My
that-
understanding is that a grandfather situation can only exist to a person who has a valid permit and use established when the law changes, if the law changes.
Okay.
We're discussing a change in the law, it hasn't technically changed yet.
Right.
But the idea being that the law does not favor retroactive application of a restriction that was, if the use was okay when it started, then as long as it's continued in a lawful manner, it can keep on going.
Okay.
Yeah, it doesn't make new opportunities for people that don't have the permit yet.
Sure. Okay, and also another question, the purpose of this meeting is, you guys are going to, I mean, is it already put in effect that it's gonna be zoned industrial?
No, there's no zone change itself being asked for here. This body receives applications from individuals or from the township when a change to the regulations is being requested for some reason.
Okay,
Whether it's a designation of a use, or whether a district is being changed, or whether a certain use is being restricted to certain districts.
gotcha.
We hold a hearing to allow the public to give comments so that we can report back to the trustees about what they're proposing to do and give some recommendation. They're still free to do whatever they're going to do, but the law requires us to conduct a hearing so people like yourself can come and say what's on their mind.
Okay,
Okay?
thank you.
All right. Anybody else want to speak? You come on up, and since I didn't have you swear in, I'm going to ask you to raise your right hand. Do you swear or affirm that the information you are about to present is true and accurate to the best of your knowledge and belief?
Yes.
Tell us your name and address, sir.
Mike McCarroll, 2126 Lakeside Avenue Northwest, Lane Township.
Okay, nice to see you, Mr.
I
Come on
don't
up
want
and
to
tell us
change
what you
anything,
want.
I just want to maybe you guys give me an idea why Stark County is the one being picked on. Because Summit County has little casinos running, Tuscarawas County has little casinos running, but they just pick on Stark County. And I think, and my personal opinion is the 5 casinos in Ohio are trying to get these places closed down because they're losing money. And that's the only reason. I don't think it's right. You realize how many senior citizens go to these places because they don't want to drive a mile and a half or an hour and a half to other casinos, then come back at dark. They go 5 minutes from their house over to one of these casinos. And they got nothing else to do in their life, so they enjoy that. And now that this Stark County Sheriff is shutting everything down. I don't know why they're doing it. They don't print the paper why they're doing it. The only thing I heard was maybe there was some drug activity after like 1 o'clock in the morning, 2 o'clock in the morning, and some people were complaining about it. I don't know how true that is, but if that's the case, then they can make them close the door at 11 o'clock.
Well, of course, we don't inspect, and I'm hearing what you're saying. We don't tell the FBI or the IRS what they're allowed or what they're supposed to do. We're here about determining what lawful uses are allowed in what locations to keep the aesthetics and safety of the township in good form for its residents.
I understand.
So,
I just had to vent, you know.
That's okay.
It's been built up to me for the last year. And I don't know why, because I own a business. And I get calls from the police department, the sheriff department for donations. And I tell them where to go. Because if they're gonna close these places up, they're not getting no money off of me. And so that's my opinion. And I understand that, I don't know why there's so many of them together. If they want to split them up, that's fine with me. But they can't close them all up.
Well, I have an opinion of why Plain Township has a large number of these places. And I'll tell you what it is, I think. We have affordable rent for businesses, and we have a good location, transportation-wise, access to people that have some means to them, and we don't have dive places. Like if you go to Canton, I hate to say it, but there are people would rather come to Plain Township than they would go to Canton. And they'd probably rather rent in Plain Township than in Jackson Township because the rent's more affordable. So we got some normal factors that good businesses consider why they would want to locate in Plain Township. And I don't think we need to apologize for that. I think that's a good thing. Unfortunately, apparently there are some that are abusing that and making it the focus of law enforcement that is bringing unnecessary or undue scrutiny, you would say, to our area here rather than others. And I hear what you're saying, but we're trying to do what's best for the
I'm not
township.
blaming Plain Township, I live in Plain Township.
Okay.
but I'm just trying to say, I don't know why they're picking on Stark County.
Um,
All of Stark County, I mean, Perry and, North Canton and Plain Township, they're picking on all of them. And I don't know why they're picking on Stark County. Because I know Tuscarawas County has 3 of them that's operating. And Summit County has 3 of them that's operating. So, but they come to Stark County. Are we that accessible to traffic?
Maybe they like us.
All right, that's all I got.
Thank you.
All right.
Am I allowed to ask another question?
Yeah, Mr. Lopez, you got another something you want to ask? Come on up.
What was the biggest complaint, like, or what was the biggest complaint area? Was it a specific area or a
So
specific?
that matter has not been presented to us. I'm thinking truthfully that you ought to be going to the township trustees, because they're the one that initiated this. Apparently they're establishing a policy that you have questions about the basis of the policy. And I'm thinking that would more properly be directed elsewhere.
Okay,
I don't know.
right. Did homeowners complain a lot? Was there a lot of?
We have no idea.
We don't handle the complaints.
Gotcha.
We just don't know.
We're an administrative body, that and this is our fact-finding part of the effort for our purposes.
I understand.
You did hear the applicant report that law enforcement expressed some concerns about it. I'm not one to necessarily second guess law enforcement and to ask them who they're looking at, and why, I mean, that wouldn't be our job anyway, so, okay?
Thank you.
All right. Anybody else want to speak? All right, before I ask for a motion, I'm going to reiterate my suggestion or statement to the applicant and ask if the applicant would want to consider requesting this be tabled or withdrawn, one or the other, so that it can be fine-tuned and presented further.
Yes, the applicant would prefer to have it tabled till the next meeting.
Do I have a motion to table it?
So moved.
Second.
You've heard, anybody want to have any further discussion about that? We've had a bit of it already, but anybody else want to say anything more?
Just curious, do you think you'll bring back a whole new motion? I mean, if you're tabling it, you're really just revising it.
And I think that's what we're doing. I don't know that will be something brand new.
The thing about tabling, I believe, just interjecting, would not have to be re-advertised, and if the applicant makes text adjustments based on a recommendation of a previously submitted application, it might actually improve the speed of the process.
That makes sense. The newbie didn't realize about the have to re-advertise, so that, yes, totally makes sense.
Good question.
Okay.
What would be the next meeting?
November the 13th.
Okay, if there's no further discussion, all those in favor of the motion to table signify by saying aye.
Aye.
Aye. Any opposed? Any abstained? Okay, that motion to table has passed unanimously, Tom, and the record would reflect that. Okay, going to our agenda for tonight. Does anybody else have any new business or whatever that they want to bring up? Anything else? If not, I'll entertain a motion to adjourn.
So moved.
And second.
Favor of adjournment signify by saying aye.
Aye.
It's unanimous. Thank you very much. The meeting is adjourned.